Good morning. We're going to start. It's 11:01, and I'm going to start with approval of the minutes. No. Oh, we're going to call the roll.
Senator Berg, Senator Carroll, Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder.
Present remotely.
Thank you. Senator Stivers, Senator Turner, Senator West, Senator Wheeler, Representative Banta,
Here.
Representative Blanton,
Here.
Representative Bratcher, Representative Cantrell, Representative Decker, Representative Elliott,
Here.
Representative Fisher, Representative Flannery, Representative Heverin,
Present.
Representative Kulkarni, Representative Lewis,
Here.
Representative Maddox, Representative McCoy, Representative Minter,
Here.
Representative Moser, Representative Nemus,
Here.
Representative Petrie,
Here.
Representative Scott, Representative Stevenson, Co-Chair Westerfield, Co-Chair Massey.
Having a quorum, we can do business now. And I'm going to make a motion on the August 18th minutes. Do I have a motion?
Motion. Second.
Motion's approved for August 18th. And all those in favor, say aye.
Aye.
Opposed? Okay. We're going to go a little bit out of order. Don't gasp in surprise. And we're going to start with non-recourse legal funding. If you could please come up and introduce yourselves. Make it work. Okay, we're ready when you are.
Madam Chair, members of the committee, I'm Mark Wilson. I'm a partner with Top Shelf Lobby. We manage advocacy in Kentucky for some of the largest brands in the world, and here we are today for the Alliance for Responsible Consumer Legal Funding. Thank you for allowing us to present today. We bring this issue before this committee to clear up some misinformation that was floated before this committee last session when the bill was introduced by my good friend, Representative John Blanton. And we thank you for that, Representative Blanton. It passed out of this committee during the session, got hung up because of the lateness of the session, did not move on off the House floor. I will let our client introduce himself and explain the product, what it is, and why there is a need for this legislation in Kentucky.
Thank you. Thank you, Madam Chairman and members of the committee. My name is Eric Schuler. I'm the president for the Alliance for Responsible Consumer Legal Funding. We're a trade association that represents companies that offer this product. There are 42 companies in our association. And what I'd like to do is kind of walk you through what the product is, but also more importantly, what it is not and what it does not do. We provide funds to a consumer that typically has a pending legal claim. In most instances, it's a car accident. And we're clear that the funds that we provide them are used for immediate household needs. So they're used to make sure they can pay their rent, mortgage, turn the lights on, and keep a roof over their head and food on the table. The funds that we provide them are associated with the claim, and typically about 5 to 10% of what we think, meaning the companies think the value of the claim is. And our average funding on a national basis is only about $2,000. So we're not giving people tens of thousands of dollars. They can go out on luxury cruises and explore the world. This is to make sure that they can sustain themselves and sustain their households while their case is making its way through the legal system. It's a non-recourse product, meaning that if their case does not come to fruition, there's no further obligation from the consumer. If they get a settlement and the settlement is less than what everybody anticipated, and after attorney's fees, medical liens, statutory liens, those are all taken care of, there's no money left over for us, the consumer owes us nothing. Even in a rare instance, and it does happen, where the consumer drops the claim, meaning they go to their attorney and say, okay, where are we with my case? And they say, well, it's going to be at least another 12 to 18 months before we get some sort of resolution on it. And they go, hey, I've got a job offer down in Florida. I'm out of here, and drops the claim. We cannot step into their shoes. We're just out the money. And we do not do a credit check on the people. We do not look at their job history. We do not look at how much money they have in the bank. None of those are factors in determining. All we're looking at is, do you have a valid legal claim, and is there a good chance you're going to be successful with it? This kind of walks you through real quickly on how the process works. The consumer contacts the funding company, gives the basic information. The first questions that are asked are, do you already have a pending legal claim, and are you represented by an attorney? If the answer is no to either one of them, the call stops. They verify the information with their consumer's attorney, because what they need to do is make sure that the information they have is accurate. And I don't know how many attorneys we have in here, but I can tell you there are occasions where a consumer will exaggerate a little bit of what their claim is worth. So we want to make sure that we're getting accurate information. They will take the information, review the claim. Most of the companies either have former personal injury attorneys or actuaries that have worked for the insurance industry review the claim. They determine how much money will be just in order to provide the funds to the consumer. They arrange for a purchase agreement with the consumer and their attorney. They contact the attorney saying, okay, we're looking to give your client, Mrs. Jones, $1,500. Are you comfortable with that? If the attorney says no, then it doesn't happen. Then the attorney says yes, they execute the contract, and the funding is then provided to the consumer. Why are we here? In 2019, there was a case, Bowling versus Prospect Funding Holdings. This is a case of, there's an old adage of pigs get fat, hogs get slaughtered. Prospect was a hog. They got greedy. And as a result, the judge in the case said, because there is nothing in Kentucky law right now on this issue, because there's nothing with guidelines in it, to protect consumers further, we're going to say this product is subject to usury and subject to champerty. What champerty is where a third party puts money into or maybe has influence over a claim. And so the judge was looking to protect the consumers. And that's what we're looking to do here, is to right that wrong, is to put in proper protections. You need to get at this. Need to put in proper protections for the consumers, the legal system, and for all those involved in the judicial system here. Okay. As you can see from the map, all the states surrounding Kentucky have statutes in place regulating this product. What we're trying to do is put Kentucky in those states that are surrounding it, and to model the legislation after a couple of them that have already passed through and have been in place. Just so you know, in every single state across the country in which we have had statute on the books, there has not been a single complaint on the industry since any of those statutes have gone into place. This is kind of what we're looking at. I know there's a lot here. I'll let you take a look at it. Making sure the companies are registered with the Commonwealth, that all the contracts are clear and understandable by the consumer, that the companies cannot have any influence in the case. This is where the champerty issue comes into play here. The company cannot go to the consumer and says, hey, you have to sell your case, I'm short of money, or you didn't get a big enough settlement, you have to hang out longer. That decision should only be with the consumer and their attorney because these are lifetime and life-changing situations. No third party should have the right to step in and make those decisions. 5 business day right of refusal, which is some of the longest in the industry, and the attorney has gone over the terms and conditions of the contract. There can be no quid pro quo between the funding companies and attorneys and also medical providers. You can normally pay any court costs, legal fees, so this can only be used for immediate household needs. It cannot be used to further litigation. It cannot be used to pay for expert witnesses, things like that. And also, too, the attorney who represents the consumer cannot have a financial interest in the funding company. We don't want any double dipping going on here. All fees shall stop at 42 months. So if the case goes on 60 months, 70 months, whatever it is, it doesn't matter. Whatever it is at the 42-month mark, that's what it is. We're going to model the rate cap restrictions after what we have passed in Indiana, which are basically 36% plus 7%. And if the funding is less than $5,000, the companies may charge an additional $250 doc prep fee. And if it's greater than $5,000, $500. This has been in place in Indiana since 2015. And again, as I state, there's not been any issues, no complaints, and no problems with it. And also the funding full notice and disclosure to the consumer, so they know exactly day one what this product's going to cost. There can be no hidden charges, no hidden fees for the contract. I'll be happy to answer any of your questions.
Okay, thank you. We do have a question from Senator Wheeler.
I guess first I would start by making a couple of points. I mean, I've used this type of product before. I mean, I generally represent the little guy out there in these types of claims that doesn't have the, let's just be blunt. This is a product that's out there for basically people without resources to some degree. And otherwise, there's really no reason for them to utilize the product because it's not a cheap product. But in certain circumstances, I think it is a necessary product. I can think of a particular instance where I had a client, her husband was killed as a result of some really bad things that happened in a nursing home. He went in on Monday with the clean skin assessment. He was coming out on Friday covered in feces with aspiration pneumonia and died. And that was her, he was the primary source of income in that household. And they lost a lot of her income. And, during the course of this litigation that took about 2.5 years, she had to borrow from one of the organizations that did this. It's not cheap, but otherwise she would not have been able to make her mortgage payment. She wouldn't have been able to pay her electric bill, and it provided a necessary lifeline for her until she could get adequate compensation to make up for what she lost as a result of that negligence. I do think that it's worthwhile to bring this product out into the open and regulate it. I think you can find studies that show that in certain circumstances, the poorest zip codes will be targeted by insurance companies to drag out their claims because they know that these folks can least afford that type of, litigation. I guess as a consumer product, I would question why anybody wouldn't want something like this to be regulated. I mean, right now we're a little bit in the Wild West. And I can see that it sounds like to me that we're wanting to put some rulemaking out there that would ensure that folks are not taken advantage of. So, I think this is a good piece of legislation. I'm glad to see my friend Representative Flannery bringing this bill.
Thank you, Senator
Thank you,
Schickel.
sir.
Thank you, Madam Chair. Explain to me, I think I know, but I want you to explain it to me, how you make your money.
The money is made on the profit of the fee that is charged. So if we have someone, it's just like banks, charge on their mortgages, they charge you a fee, and that's how they make their money. It's the same type of transaction.
Well, I'm glad to hear that. So there's no, for those of us that aren't lawyers and don't understand system like maybe some others in the room or some people watching. So because I know in some of these type of arrangements, there's no advantage to your company then if there's a large settlement that doesn't factor into what you collect.
No, and in fact, an interesting point with this is, let's say we valued a claim at $50,000, and we gave the person $2,000, and the case went down the tubes, and it actually settled for $10,000, and we walked away with practically nothing. Let's say in the reverse of that, we valued the claim at $50,000 and actually settled for $500,000. We don't get anything more than what's on our contracted amount. So whatever on our contracted amount, the consumer will know that day one what's the maximum that is their obligation is on that contract. It can never exceed that. It can only go down from there for the funding company. So if they have a fabulous lawyer that gets them $500,000, well, it's what it is. If things go in the tubes and it's less, then we walk away with less, or in some instances, nothing.
Thank you.
Okay, Representative Nemus.
Thank you, Madam Chairwoman. Thank you for bringing this. I appreciate it. Representative Flannery, I think this is an area that's going to need revision. We have these in Kentucky already, and I think largely they're unregulated and predatory. I've had some clients who've had these types of loans, and like Senator Wheeler said, they're largely unresourced. I want to have 2 points I want to make. One of them is not related to this particular issue, but it's related more globally on behalf of our clients out in Kentucky. And then one that I want to make sure I have a clarification on. And that is, it's time in Kentucky to increase PIP. It's 10,000 right now. It's been 10,000 forever. PIP is supposed to allow the person who's been harmed to have immediate access to funds. It's been 10,000. It needs to grow. It needs to go up. So I want to go ahead and put that marker in that PIP needs to increase. It's overtime for that. But my question to you is this: I noticed on your flow chart that a lawyer is going to be involved, and I want to clarify what kind of involvement, because I don't want to be involved. I'll tell you, I'll help understand like forward information so you can make your own judgment as to whether you think a claim is worthy for your company. But I don't think lawyers in any way need to be signing anything or verifying anything or guaranteeing anything. They don't need to be involved in this. This is a relationship between you and the individual citizen. But I just want to make sure the lawyer is not making any representations or taking on any liability or guarantee or anything of that nature.
Yeah, no, I appreciate the representative. What we're saying in there is that the attorney has gone over the terms and conditions with their client, so they understand kind of what they're getting themselves into, so to speak. And then that also, too, is that they will pay the companies out of the proceeds of the settlement. That acknowledgment's there up front. So when the check comes in, that they're on the list to get paid out of the proceeds of the settlement. The attorney at no time guarantees this product in any way, shape, or form at any time along the line.
Okay, we have Senator Turner.
Thank you, Madam Chairman. Couple questions. Did I understand you say the interest rate is 36%?
That's what we're proposing. We're looking to model it after what we have already passed in Indiana, 36% plus 7%.
And I think you also said that if the client doesn't receive anything through the representation of the attorney, whoever, you all get nothing.
We get absolutely nothing. We have no further claims. We cannot report them to a credit bureau. We cannot do anything negative to them whatsoever. We can only get it if they have a positive outcome from the settlement.
And a follow-up question, Madam Chair, if I can. Can you give us some idea of a quantity number of people in Kentucky that use it? I know I've had a constituent that used it, and it's in workers' comp and other things. So can you give us the public will know how I guess how you all work as a state aid group of people. So.
To be honest, Senator, none of my members are currently operating in Kentucky because of that decision. It's making it very ambiguous. So we would rather go into a state where there are clear delineations of it, and that's why the reasons why we're proposing this legislation. So we can have more companies come in here that do it under a regulatory scheme rather than something that's just wildly out there.
One follow.
And I would add too, if you don't mind, Senator and Madam Chair, I would add, I think anecdotally we have kind of experienced that maybe up to 2,000 calls a year to some of Mr. Schuler's members of his association, and they just have to decline. There are companies, I know there's one in Louisville, and I know of one in the eastern part of the Appalachia region of the state that offer these types of service currently, but if 2,000 Kentuckians are trying to get a product that the bigger companies that want to be regulated in the United States and in Kentucky specifically, they won't come here unless they're regulated. So,
Thank you, Madam Chair. I think he answered the question because I know that the business has been offered in the state for years and years and years. So, thank you.
Okay. Representative Flannery?
I'd just like to amplify something here. I'm going to quote someone that's probably never been quoted before in the General Assembly. That would be 15-time world champion Ric Flair. And he always had a saying, whether you like it or whether you don't like it, you better learn to love it because it's the best thing going today. And what I mean by that, as it applies to this, is whether or not this proposal would be enacted, this is still going to go on. And it's not a transaction that I find happens a whole lot, in at least my experience in practicing law and talking to other attorneys. But I believe this concept that we're proposing here is a good thing because it does set up guardrails for the consumer. It takes it out of a shadowy space and puts it into a space to where we know that there are certain measures that are there to protect the consumer, and I believe it's good for the businesses that operate in this space, the consumer. It's good for the legal system to do this. So I guess if you have questions about this, what I want to emphasize is these transactions are still going to happen even if we're not enacting this. So I think that the best reason to do this is to get it out there and allow those guardrails to be put up to provide those protections that are good for everyone.
Okay. Thank you. Senator Berg?
Thank you. I apologize for being late. 64 was bad on me. I just want to clarify. You're saying on a $50,000 claim, your average would be between 5 and 10%. So I, took the median at 7.5%. You're lending somebody $2,000 and expecting a return of $3,750 if you go with that average. Mm-hmm. How does that add up to 36%? That's almost 50%. I'm trying to figure out. I mean, to my mind, this is predatory lending. This is taking advantage of people who are in very bad positions. And I just don't understand the math. Can somebody tell me where I'm wrong?
Well, and forgive me, I'm not a math whiz, so I'm taking you at your word of what the numbers are. You have to also take a look at this too in traditional lending financial products. Is they look at a consumer's credit, they look at their job history, they look at their ability to repay, they look at what their FICO score is. None of those come into play in these types of transactions. The only thing we're concerned with is, do you have a valid legal claim, and is there a greater than 50% probability you're going to be successful on it? The other thing, too, we have to remember, too, with these products, other than traditional lending products, there is no periodic payment along the way for the consumer. So in other words, we give the consumer money in January, and their case, January of 2020, and their case settles in July of 2023. They're not making any payments along the way. They're not required to. And so that is also has to be taken into consideration as a time value of money that goes along with it for the companies, because it costs them money to put out money. So none of those typical factors that go into a traditional lending products come into play here. We don't that's why this product is not considered a loan in most states.
Okay, and we have a final follow-up from Senator Wheeler.
Thank you, Madam Chairman. I guess one question, do you all send, if you don't get paid back, do you send out any 1099 or anything to the consumer that took advantage of the product?
If it's done as a funding, no. If it is done as a loan, the IRS has actually weighed in on this. Is if this product is offered as a loan, traditional loan, where we have to go through all the loan process and it ends up to where we get nothing back, we then, under federal guidelines, have to 1099 that person.
Sure.
If we're doing it as a funding, as we're proposing here, and we get absolutely zero, there is no federal tax obligation to that consumer.
Okay.
So it's better for the consumer.
Yeah, and thank you, Madam Chairman. Just maybe if I could briefly address Senator Berg's comments, and it is, as someone who has utilized these products, it's something you only want to do on rare occasions, and these people don't have anywhere else to go, so it's better than losing your vehicle or getting put out on the street in some circumstances. I know I counsel my clients in these circumstances is that, if there's any other way, if you've got family, if you've got friends that can help you, that's a better way to go. But I mean, there's some people that, essentially need this product, and it's non-recourse. So.
Okay, we have someone on Zoom who is opposed. His name is Carrie Silverman. We're getting them up on Zoom now. Did you guys have something else to add?
I was just going to conclude, Madam Chair, if I might, and just say that a wise lobbyist, when I first started lobbying 20 years ago, told me, Mark, you can fight the market, but the market will always win. And that being said, there's a need, obviously, for this product because of what I think Senator Wheeler alluded to was perhaps some of the bigger companies that do property casualty work and in the insurance space, maybe, and we've been told by other lawyers that they do target the poorest of the poor zip codes in the state, try to back them up against the wall. I think even Representative Flannery maybe even had a client that the company was trying to, the insurer was trying to force into a lower settlement than was properly owed and due. And so because of that, and these people have a lack of resources, they need a little something. I think Representative Flannery's client just needed some money to help pay for Christmas for his son. And even though I think Representative Flannery discouraged the use of the loan product, he said, if you have to, do it, and so these product mechanisms, these funding mechanisms are currently in place in the Commonwealth of Kentucky with no guardrails whatsoever. So it is the wild, wild west. And I think what these national companies that Mr. Schuler represents would like to see happen is have some guardrails put up and some regulation put up so that they can provide something for the market space in Kentucky. So we do appreciate your time, Madam Chair, and thanks for allowing us to do that. So,
thank you. And now we'll hear from Mr. Silverman on Zoom.
Good morning, Madam Chair. Can you hear me okay?
Yes.
Okay. Thank you for taking the time to allow me to testify today, members of the committee. My name is Carrie Silverman. I'm here on behalf of the American Tort Reform Association, ATRA, and ATRA has concerns with any type of proposed legislation that's going to legalize the lawsuit loans that courts have now found are prohibited in Kentucky, even though they do happen, and that would allow lenders to charge excessive interest rates in exchange for a licensing requirement and what we view as relatively weak regulations. Over the years, ATRA's watched the lawsuit lending industry emerge and grow with concern, and a quick search on the web will pull up numerous companies advertising cash for lawsuits, and these businesses are offering people who have experienced an injury and are vulnerable, sometimes elderly, quick cash in exchange for being entitled to a portion of their settlement. The companies that promote these arrangements, they'll claim that they're not subject to lending laws that protect ordinary consumers because they offer what we're discussing today, the non-recourse loans, meaning that the lender will only get paid out of the settlement or judgment, sort of like a contingency fee lawyer. But in actuality, these arrangements, they can take advantage of consumers with extraordinarily high payday loan type rates. And after taking a relatively small loan, that rate and the passage of time that happens in litigation can eat up their entire settlement. Mr. Schuler said earlier that the average loan is $2,000. That may be true, but we've seen substantially higher loans. And the legislation that we saw last session allowed loans, I think, were as high as $15,000. There's really little true risk involved in most of these types of cases. Lenders know that it's almost certain that a consumer will receive a settlement from the defendant or its insurer, whether it's a slip and fall, a fender bender, or some other action. It's really just a matter of time. That's the time during which the lender profits from the very high interest rate. And it would be foolish for them to make a loan otherwise. They're smart. They evaluate these cases. They pick the ones they know are going to settle, have a very high chance of settlement. From a civil justice perspective, these types of arrangements are also problematic. They complicate the ability of parties to resolve litigation. They drive up settlement demands, and that's because a person who's taken out a lawsuit loan must not only think about how much of his or her settlement is going to go for the attorney's fees and costs, which could be 35, 40% off the top, but how much of what now remains from that will then have to go to pay the lawsuit loan and the interest rate. And once a plaintiff takes out a lawsuit loan for thousands of dollars, I have a hard time believing that the arrangement is going to let them simply walk away from the litigation without repaying it for no reason. You take out a loan for $15,000, you're not just going to keep the money, even if it turns out the lawsuit shouldn't have been brought in the first place. These arrangements, they can also encourage litigation, as some people who may not have sued might be enticed by the prospect of getting fast money. And keep in mind that lawsuit lending isn't needed to promote access to justice. We already have contingency fees for that reason. Earlier in the testimony today, you heard just a little bit about the bowling case. Mr. Schuler mentioned it. I want to tell you a little bit more about it. I mean, that was a case where a Kentucky resident, Christopher Bowling, was seriously injured when a gas can ignited. And he sued the manufacturer of the can, claiming it was defective. And during that litigation, he took out 4 lawsuit loans totaling $30,000. The loans accrued interest at a rate of 4.99% per month. And when that's compounded monthly, he was subject to an effective annual rate of nearly 79%. And when the lawsuit settled about 5 years later, the outstanding balance on his $30,000 loan was over $340,000, more than 11 times the amount he borrowed, and likely a substantial part of the settlement that he would have received as compensation for the severe burns he had. He refused to pay and he sued the lawsuit lender. And what the federal district court and unanimous panel of the Sixth Circuit found was that those loans were unenforceable under Kentucky law. And that's because lawsuit lending violates Kentucky's existing statutory prohibition on what's known as champerty, which doesn't allow third parties to have a financial interest in litigation, aside from the parties and their lawyers. That prohibition, the court found, reflects Kentucky's strong public policy against arrangements that can compel a party to move forward with a claim he doesn't want to continue with. And it could complicate the ability to settle, and it can encourage litigation. That's what the court said. The court also ruled that the loan agreements clearly violated the usury law, the state which doesn't allow an APR above 8%. And what the court did was it invalidated the agreement, required the consumer to pay only the principal on the lender's cost, $34,000 and change, as opposed to $340,000. And that's what consumer protection is. And that's what you have now in Kentucky, even if illegal practices are happening anyway. Last session, we saw a bill introduced which would have carved out lawsuit loans from the champerty statute, carved out lawsuit loans from the usury statute, and replaced those strong protections with a licensing requirement that legitimizes these types of practices and will let lawsuit loans flourish more. As introduced, that proposal had no limit on the high interest rates that insurers could charge, interest rate that lenders could charge. And other consumer loans in Kentucky and even payday lending is subject to fee limits. And I believe those limits are substantially less than the 36% rate that was mentioned today. So for those types of policy reasons that have long prohibited these kinds of loans, ATRA doesn't support legislation that would legalize and expand lawsuit lending. And if the legislature is going to move forward with a proposal, we believe at minimum that number one, lawsuit loans should be subject to the state's existing usury law, and that the agreement should be automatically disclosed in litigation so that all parties and the court are aware that there's this outside factor that may be complicating the ability to reach a fair and reasonable settlement. Thank you.
Thank you, Mr. Silverman. We have a question from Senator Schroeder.
Thank you, Madam Chair. Can you hear me all right?
Yes, I can.
Thank you. I'll direct this at Mr. Silverman. I think really anyone could probably answer, but just so I'm not asking a wide audience. We heard today that these loans are already happening in Kentucky without legislation. If that's the case, though, there would be non-enforceable loans, and then the company would just kind of be stuck with the debt, right? That wouldn't necessarily be on the consumer or the potential plaintiff or plaintiff. Is that right?
I think the answer to your question is that this industry is operating in a very legal gray area right now, and that's the reason that they're seeking, and they can answer for themselves, seeking legislation here to make sure that they are able to enforce these agreements. And right now, there's a chance that if a consumer who took out a loan decides they're just not going to repay it, they could fight it and challenge it as unenforceable in a court. I don't know how often that happens. It happened in Mr. Bowling's case in those egregious circumstances. More likely, most consumers, the vast majority, are just agreeing to these things and paying their debts on them.
Okay, thank you. My second question was, for the attorneys, the Kentucky Bar Association has, I guess, limitations on who you can contact as a potential client, and a degree of relationship, if just to avoid everyone reaching out to, you see someone that was in an accident, maybe mentioned in a paper, and all of a sudden they're getting 100 phone calls. So obviously the Kentucky Bar Association has an interest in protecting those kind of individuals. Does this industry, are there any prohibitions, or is it pretty much wide open as far as could a potential plaintiff get calls from 45 different one of these companies saying, hey, we have the best rates, we can help you out?
That's a great question, and I'm not sure the answer to it, but it certainly should be a concern if it's not something that's included in any legislation that's introduced. I don't know of a reason that lawsuit lenders, as they're not attorneys, would be prohibited from doing exactly that.
Thank you, Madam Chair.
Thank you. And we've got a follow-up from Representative Flannery.
It's more of a comment, Madam Chair, if I can. Mr. Silverman, in his comments, made a statement that it's just generally a matter of time before these cases resolve. And I think that's part of the reason why this product is necessary, because what should be oftentimes something that should happen within 6 months to a year oftentimes can be delayed and drug out for years, sometimes potentially decades, depending on what is going on in this case. And so I know oftentimes my clients have found out that they're not always in good hands, and that their insurer is not always a good neighbor and there for them. So, and that's one of the reasons that we have to unfortunately have these types of products, because it is a matter of time, but is that millennia or eons or just a few months or days? So I think that's something that needs to be, addressed and put into the record, and why this product there's a market for it, because there's a big difference in the value of time and what time means to each of the opposing parties in litigation.
Thank you. Seeing no further questions. Oh, I'm sorry. I forgot Senator Wheeler.
This question, I guess, is for Mr. Silverman. Why would your organization be opposed to some consumer protections regarding these products if, in fact, you feel that they're exploiting consumers?
We're not opposed to consumer protections. We think there are already strong protections in place, and those are the Champerty statutes and the usury statute. And we look at the bill like this as actually exempting it from the existing consumer protections and instead substituting something that is far less. I mean, the interest, there was no interest rate cap last session. And the rate that I think is being proposed now is less than you'd see. It's a much higher rate than you see for other types of consumer loans in the state.
And I guess a follow-up, I mean, I understand you say you're out here for consumers, but, you know, I'm sure many of the people that probably donate to your organization are banks that charge 28 or 29% a year on credit cards and everything, and I never see your organization out there arguing against those types of for protections for those type of interest rates. So, these are types of situations where people may have no other recourse to survive while they're going through a very difficult period of their time in their life where they've been harmed by somebody that's no fault of their own. They may not have the ability to access credit. They may not have the ability to pay their bills. And I mean, I'm not saying as an attorney that represents folks, I don't recommend this per se, but occasionally there's no other place to fall back on. And as far as the bowling decision, I don't know that I think you first said illegal, then you went into gray area. I think that, maybe they held that in certain circumstances these contracts are voidable, but at the same time, I want to bring some order, law and order to the Wild West here, and I think that this bill is a good start to do that for a product that I would agree should be rarely used, but does have a rare usefulness in certain circumstances. So thank you, Madam Chair.
Certainly. Mr. Schuler, briefly.
Yes, thank you, please. Real quick regarding the question I was asked about marketing, our companies are all inbound, meaning if they get contacted by the consumer, they do not do any outbound marketing. In other words, look at accident reports and send letters out to consumers. It's all inbound. And one final thing I want to state is if this statute that we're proposing had been in place, the bowling decision never would have happened. The rate never would have got as high as it would have. The issues that were addressed by the court never would have happened because statutorily they would have been illegal. And I thank you for your time.
Okay. Thank you. Thank you, gentlemen. Appreciate your
Madam Chair.
testimony.
Thank you.
And at this time, if we could have the child support update. You're going down there? Okay. Anybody coming up for the child support?
I don't know who we have here. I know Lily and Steve, come on up. While they're coming up, I do want to thank everybody. I apologize for being late. I was getting blood drawn. Most of you know what happened to me last week, and I'm grateful to be alive and living in the time that we live in because I had a stent put into a 95% blockage in my widowmaker of my heart. And so I've been told to take it easy by many of you, and I'm trying to do what I can. It's hard for me, but I'm trying. And I appreciate all your support. So sorry for being late. I had to get preparation for some tests next week, had to get that done. So thank you for your patience. You guys and gals are my family, and I appreciate it. So thank you. The reason we're doing this piece today is because many of you know that we passed child support. We improved the child support guidelines 2 sessions ago, and that it needed to be done because it hadn't been done in over 20 years. And so we were having federal issues because of funding issues that we had to get some upgrades done, and we did that. But one of the things that's transpired during that time and over the last several years is Kentucky is a state where there's a presumption of shared parenting and shared custody when there's a domestic situation. So we had to start looking at how we could fairly give credit, amenable credit, if there's a situation where there's overnight visitations, et cetera. Where do you have those credits given? How do you work through that process? This actually began with my good friend and colleague, Representative Petrie, and it's a very complex situation. They had worked on it, I think, back in 2000.
2019, and we have an expert that's involved in this, and they had worked on along the lines with what's called the Oregon method. Well, there were some issues. We wanted to have our own Kentucky method for a variety of reasons, but we've looked at Oregon, Colorado, Arizona, Missouri, Kentucky, and some other states, and we have come up with what we think is a reasonable solution, but it's complicated. A lot of you are hearing from your judges back at home, and that's why we wanted to have this session this morning to let you know information about this so you could communicate that back to your judges at home. We have put a delay on this. If you remember last year, we did a repeal, and then we put a bar until March 31 of 2023 for implementation of this. And we also directed that the Child Support Commission prepare a manual or a handbook for practitioners, for judges. Our goal is not to make it complicated, because it can become that way, and they are already overburdened with work, and we don't want it to be complicated for judges, practitioners, or the obligors or obligees. So we've been working on that diligently through the interim. This past week, we had a work group meeting, and we had Dr. Venor, who is an expert in this field and who worked back in 2019 on this project. We had Judge Lucinda Masterton. We had attorney Anita Britton. We had some other judges involved in the call, and we had a really robust discussion, I think. And now there's a better understanding among the people about what we're trying to accomplish and what needs to be done. So I will tell you that Lily, that is here today, and Steve, they've forgotten more than I know about child support, but they're going to give an overview today, and we want you to have information to take back to your judges. And I do want to give a shout out, I'd be remiss if I didn't, to Lexington Sowers, who's the drafter. She has done yeoman's work on this in trying to get us there, and it's really hard to draft this kind of thing. So with that, I'll turn it over to Lily. I just wanted to kind of set the precedent of what we're trying to accomplish and why we have them here today.
Thank you. When we started looking at drafting the guideline, there were a few characteristics.
Lily, can you hit the button and pull that closer to you?
Closer. All right.
And if you don't mind, both introducing yourselves just for the record.
I'm Lily Pattison. I'm the Child Support Enforcement 4D Director for the Commonwealth of Kentucky. So, as I stated, when we first started with the Kentucky formula, there were a few components we wanted to look at. Something that was easy to use, sensible, fair, appropriate, had a gradual change with more overnights, and also reduced litigation regarding child support as well as for parenting time or custody visitation arrangements. I know different jurisdictions may call those different things. Kentucky had a patchwork when we dealt with parenting time credit. McGinnis is commonly used. It's very simple. I used it while I was in private practice. It is basically calculating the child support and offsetting, taking no consideration to the economic factors, cluster effects of how many nights most people have regarding parenting time, and really what the statute was regarding shared parenting. I know Oregon was one of the methods that were looked at a few years ago. There were some concerns regarding the cumbersome nature of Oregon. It has an adjustment each night. And, again, we're looking at being fair, something easy to use, something someone, even a lay person, can look at and understand why are they getting credit and why someone is getting their child support reduced because the other person has more nights. That's how we arrived looking at Iowa, Missouri, and Arizona, and specifically Arizona. They've had their shared parenting credit since 1990s. They had some adjustment in the early years, but it has pretty much stayed stable. And actually, they have just recently updated their guideline calculation, and it looks actually like ours. And I think part of that is we're taking into consideration the economic child rearing cost, what Kentucky in general have as a standard parenting schedule throughout the state. Obviously, each jurisdiction, each judge may have a slightly different standard parenting schedule. So we did take that in consideration when we prepared our standard parenting agreement schedule. We did look at studies from other states and nationally where parenting times clustered, and that's why you also see that there's a range within our calculation, and we took those clusters and came up with a method that matched Kentucky. It is unique to us. It's not going to look like Iowa, Arizona, and Missouri exactly. We do not give a dollar-to-dollar consideration. So just because a child is somewhere else for 30% of the time, we do not reduce the child support by dollar to dollar, because we understand the economic factor of introducing a child an X amount of nights may only reduce your costs a certain percentage and increase the other parent's costs a certain percentage. Again, it's not a dollar per dollar. That's why you see in that calculation range sometimes a 0.5. Again, just because you have the child 30% of the time, you don't get a reduction of 30%, because economically the cost of child rearing doesn't work that way in general. And I think that's about the points I wanted to share. I have Dr. Venor, who's also online today. She will be able to share more studies if there's specific numbers you would be interested in hearing. Thank you.
I did want this committee to meet Dr. Venor. She has been doing this for many, many years. She worked with the Arizona project. She worked with Oregon. She's worked with us. And so you have the draft from last year that we are working from. Judges initially had some concerns that they thought it was going to be overly complicated. That was the purpose of coming up with the manual. But as we work towards getting this done, we do need to do this piece of legislation in the beginning of next year. We have invited, as part of our work group, Representative Elliott to be part of that, because we tried to find folks that had engaged in child support computations in the past. And ironically, we have several lawyers in the General Assembly, but not all of them do this kind of work, and it's a fairly complex area of work. So we wanted to give you an overview so that if you had questions or you had things from your constituents or your judges that they wanted us to address, we could do that over the next 3 months in order to get the fine-tuning of the legislation ready for it to be introduced in January, because we have that deadline that is hanging over us of March 31. So for those judges that think we've already done something, the fact is we haven't done anything with the overnight visitation or shared parenting time. We have upgraded the child support guidelines, the timetables, but the difference is in the past, the guidelines and the timetables or money tables kind of went parallel, work together. This is a little different with shared parenting, because we're talking about how do you define what an overnight is. Is an overnight, for Arizona, for instance, in Arizona, an overnight's considered if a parent has the child more than 3 hours. In Oregon, it's 12 hours. Here in Kentucky, we defined it thus far as a 12-hour period. And so that doesn't allow somebody just to get the child, basically not have to do anything, just have the child overnight, turn the child over the next morning, not do anything, but then get credit against the child support amount they're paying while the child merely was sleeping at the home. And so that's the kinds of things that we're working through. Lily, you did a great presentation, and your compadre there has been great to work with. Dr. Venor, if you could just introduce yourself to the committee and add some comments, we'd be much appreciated.
Thank you. I'm Dr. Jane Venor. I'm an economist with Center for Policy Research. We provide technical assistance to about 30 states on their child support guidelines. We're a nonprofit organization.
Well, she's going, but we're not going. Oh, if you can hear us, Dr. Venor, your internet connection or something, we can see you great, but we can't hear you.
But Lily said that there was a lot of thought. There were a lot of people that came to the table, judges, the commission, people from the agency, Representative Macy's been really diligent as far as considering all the options, what are appropriate for Kentucky, that are fair, just, and easy to use. So thank you for that opportunity to add that.
And Dr. Venor, and the group might have some questions, but I will ask you this. Obviously, in the past, they had looked at the Oregon method, which was somewhat cumbersome and complicated. And then we looked at the Arizona, and what we created was more of a hybrid with our own delineations, making it the Kentucky model, if you will. And that's, in other words, we took the best of both programs, tried to streamline it, and make it so it was workable for the Commonwealth. I will also add, before I forget it, that we received an email from Craig Ross that prepares the child support worksheets, and they actually were astounded with what they believed how simple the process will be. So a lot of the confusion and fear of the judges we think will be mitigated once the manual is prepared and comes out, and Dr. Venor is going to continue to work with us as we move towards that goal. So Dr. Venor, can you basically summarize where we have come to with the conversations we've had regarding the proposal for this body in Kentucky?
Yeah, I think I feel like I'm repeating Lily to a certain degree because I think she did an excellent job. But what came about is a very simple table that has some income intervals that are that match what Kentucky uses for their time sharing. It's very Kentucky specific and consideration of income ranges. So there's not our time sharing ranges, that there isn't a gaining of more or wanting of more time just to affect the child support order. And that's what you'll see in there. And I'm not sure if I quite answered your question, but
you did. I just will ask this group again. They might have some questions. I don't know, but if they do, because they have constituents that they're back in their locations and judges, if they have particular questions, we want to give them that opportunity. So. And I don't see anyone that is asking questions at this time. I will tell the committee that we are continuing to have work groups, and we will have one in October, November, and to have a final product to this body by January. If you have any interest in that, or you need more information regarding that, or should you have a particular judge that is bending your ear and would like us to communicate with them, we'll be glad to do that. So thank you very much. Thank you, Dr. Venor. Thank you, Lily. Thank you, Mr. Vino, for your time today. And I'll yield back to my colleague, Representative Banta.
Thank you. Next up, we have the Department of Public Advocacy update. If you can come to the front and introduce yourselves, please.
I will also weigh in on this really quick. We also met as a work group with Representative Petrie. I just want to remind this body that last year we did about a $7 million Band-Aid to help DPA. This has become a real issue because people are entitled to representation. And when the resources and the personnel are seriously short, there becomes an issue of whether people are getting the constitutional representation they're legally entitled to. So what Representative Petrie and I decided to do is to try to embark on working with DPA to find out how they've been funded in the past. Why are we having to do Band-Aids? What can we do going forward to make sure that doesn't occur? And how can we get some parity in the pay? And so they did a wonderful presentation to that small work group with Representative Petrie and I. And I've asked Mr. Preston to kind of summarize or go through that again with this group so that the lawyers in this committee can weigh in and maybe have some ideas that we can utilize as we go forward. So that's all I have. Gentlemen, the floor is yours.
Thank you, Chair Massey and Vice Chair Banta. My name is Damon Preston. I'm the public advocate for Kentucky.
I'm Scott West. I'm the Deputy Public Advocate.
We are happy to be here today, and we will be as quick as we can running through this information. The first message I want to deliver very clearly is gratefulness and appreciation for the assistance that you gave DPA in the last budget. As Representative Massey mentioned, there was a little over $7 million provided to try to stop the bleeding on our turnover. In calendar year 2021, we lost 100 attorneys out of DPA. As context, we only have about 300, so 1 out of 3 attorneys walked out the door last year. And we had trouble filling vacancies. I'll talk about a little bit of that in the details. But you came to our rescue, and I just want to say, if I have no other message today, it's appreciation and thank you for that assistance. Here's a quick snapshot of what DPA is as an agency. We have about 570 employees total. That is personnel positions. It has been going on 2 years at this point since we have had that number of employees. We are still not back to full staffing simply because hiring cannot keep pace with turnover. There was about a week, and I'm not joking, there was about a week in the year 2020, when we had full staffing. And then it went back to not full staffing. And as far as consistently being at our peak, it's been probably 3 years. But out of that 570 employees, there's the breakdown of the positions, a little over 330 attorney positions. And then we've got alternative sentencing workers, which is a very successful program of finding alternative sentencing options for our clients. We're not just about winning cases. We want to change our clients' future and provide opportunities, recognizing that it's not simply guilty, go to jail, not guilty, go out the back door of the courtroom. There are most cases fall in between, that there can be resources available, and alternative sentencing workers help with that. We have 45 investigators on staff. That works out to about 1 per office. A few of our larger offices have more than 1. We have a law operations that's like any major organization. We have HR and fiscal and IT, with 23 employees there. 8 are in our training. Turnover, as you can imagine, creates huge training needs, because as soon as you get somebody trained, they leave and you have to train the new person. So that is a full-time, 365-day-a-year job. It's not simply, we have a training season and move on. That's all the time. I would recognize Melanie Foote is here today. She is our education and training branch manager, and she does a great job on training our new employees. 6 people in our office, just to emphasize, we don't spend a lot of our resources on our central administration. So it's Scott and me and 4 other employees are the entire staff of our central office. And then, as you probably know, protection and advocacy is an independent division that has been assigned and dedicated to DPA. Those are not public defenders. Those are advocates, both attorney and non-attorney advocates for people with disabilities in Kentucky, do a valuable service, and that's part of our agency. But they are independent, and so the rest of my comments today will focus on the public defender side of DPA. Within the bill, the budget bill providing additional funding for us, provided funding for these specific positions. It did include, and I appreciate it, language which said attorneys and staff, and included these positions. So I do believe there's some flexibility there to use them beyond this, but these are our primary focus. We have 5 levels of staff attorney. Entry level's 1. After about a year, a little over a year, they would be promoted to a 2. Later in their career, at about 4 years, they would be a 3. And then after that, the only options for promotions are to go into leadership. This provides a challenge in itself, in that if someone does not want to be a leader or doesn't have the skill set to be a leader, then basically they've maxed out on their position after 4 years. And we'd like them to have a career with us, but they've maxed out on position very early in that career if they don't go into leadership. Our supervisors and managers, the most important thing I want to say about those employees is they're not simply leaders. They also have substantial, and in many cases, full caseloads in addition to their leadership responsibilities. The increases, what have we done with the money? Well, so far we've spent very little of it. The Personnel Cabinet has been very cooperative with us in implementing the raises, but due to their own resource limitations, they let us know shortly after the budget passed that it would not be able to be implemented until after we were into the fiscal year. We actually, because of our turnover, had some funding available, and I went to them in late April and early May and said, could we make this effective June 1st? Can we actually jump the gun? Because we could fund these raises a little sooner. And August 15th was the best they could do. So these raises only became effective August 15th, which means as of today, it's only affected one paycheck because you're paid 30 days after the effective date. So the September 15th paycheck, our attorneys got a nice increased amount in their paychecks and have expressed their appreciation, which I will share with you, that they are very appreciative of that. The annualized cost of salary will be about $3.5 million for those raises. The total cost, which includes all the associated costs with a salary increase, would be about 7.2, which was almost exactly the amount of the additional funding. Backwards. What we did, the way we did this, we didn't want to just pick and choose and have Damon's favorites and Scott's favorites employees get the biggest raises. We came up with a pay schedule, which broke all of our attorneys down by position, which I've explained, 1, 2, 3, supervisor and manager, and their experience. And we set levels at the baseline level, and then 3 years, 6 years, 10 years, 15, and 20. And we had a calculation for how we defined experience. Work for DPA is obviously year for year. If somebody came to us with experience outside DPA, we had a process for equating that to state service. These increases were aimed at improving retention and recruiting. Retention as the most important. Stop the bleeding, keep people from leaving, but then also to recruit not only future law graduates, but also some of the people that left us. Part of our goal was if they left us in 2021 because we simply didn't pay enough, maybe we could increase the salary in a way that some of those people who have already been trained, they've already shown that they're dedicated to serving our clients, that they come back. The raises ranged from 8%. Everybody got at least 8% because that was the general state employee raise for this year. So everybody got at least 8%. That was included within the raises. And it went up to 44%. The average raise was 22%, and of our attorneys, almost 300, meaning is about 90% of our attorneys qualified under our schedule for a raise higher than 8%. Now 44, that might jump out at you. Wow, that's a huge raise. Let me tell you who got the highest end of the raises. We had employees, and this was part of my budget presentation before the budget passed. We had attorneys who had worked for us for 15, 17, 18 years that were making $52,000 a year. And so they, under our pay schedule, the 20-year, well, in fact, it's the next slide, the 20-year staff attorney 2s and staff attorney 3s get into the 70s. Well, the math from 52 up to 70 is about 40%. And so those are the people that got the highest raises, the people that have dedicated their career to the Commonwealth of Kentucky and to DPA specifically, but still were working in the low 50s. So these are our increases. It's important that you see these, that you might say 20% raise is huge, 40% raise is huge. Well, this is where we wound up. Licensed attorneys holding people's freedom in their hands, helping people who cannot afford an attorney to not spend significant amount of time, and in some cases the rest of their lives in prison. They're making $52,000, $59,000 if they've got a little bit of experience. Our top level attorneys are making $64,000. Our supervisors, people that are responsible for literally thousands of cases in your communities, are making $70,000. These are not outrageous salaries, and this is after the increase. So we still have work to do to if you're a graduating lawyer and you've got $60,000, $80,000 or more in law school loans, would you come work for $52,000? Fortunately, some people would, but many wouldn't. And so we still have work to do, but this is where we are right now after the increases. Some of the challenges we face, I'm sure you're aware of the ranges in state government salaries. And so part of the challenge is the midpoints, which is essentially, there are mechanics that I don't need to get into here, but essentially the midpoint of a state classification range is basically the highest you can offer someone for that position. in most circumstances. And I've listed those midpoints here. So if I wanted to hire a very experienced staff attorney, under most circumstances, the most I could offer them is $75,000. I mean, that's a substantial salary, and I don't want to undercut that. But that limits the audience for who would come to us. The most I can offer a new attorney, fresh out of law school, would be $62,000. I know the personnel cabinet under Chair Petrie's direction is working on these classifications, but this is a challenge. The most I can offer a supervisor, $82,000, or a manager, $90,000. Another challenge we have is our non-merit attorney leaders. Scott and I are, of course, non-merit, but we have 5 attorney leaders that are non-merit. Our division directors, they are responsible for the trial division and the post-trial division. In the trial division, that person's responsible for overseeing the delivery of services in about 150,000 cases. Once we put the salary increases in place, our managers were making more than our division director because their salaries are set by the governor, and they were not included on our pay schedule. Now, I have contacted the governor's office through the Justice Cabinet, and they have committed to me that will be addressed, and I believe it's in the works. It's not effective yet, but that's a challenge, that we have to go through this different system to address the salaries of non-merit attorney leaders. I want to quickly talk about, and I just want to bring this information forward. If you've never looked at the comparison between DPA and the prosecutors, it's worth looking at. A lot of times when the comparative funding comes up, the first thing that's mentioned is that prosecutors have 100% of the cases and DPA doesn't, and that's absolutely true. By definition, prosecutors have 100% because they're the ones bringing the charges. But DPA isn't close to 100% of the funding of prosecutors. In fact, this is the funding. Prosecutors, the 2 lines here are with and without the AG. The lower line is if you simply combine the county attorney, state funding for county attorney offices, and state funding for Commonwealth attorney offices, it's about consistently a little over 60% more than DPA is funded. Now, DPA does work that the Commonwealth county attorneys don't do. The most prevalent are appeals. Commonwealth and county attorneys, for the most part, don't do appeals. That's why I've included the AG line, because the Attorney General's office does the criminal appeals. And the Attorney General, just to be clear, I've not included all of General Cameron's budget here. This is just the criminal defense portion of the AG's budget. They have a line item that's only adding that in. So this doesn't include any of the civil work or the other functions of the Attorney General's office. But when that's included, it's around 80% more. If you prefer to think of it in the other way of flipping it, what percentage are we of them? These are the same numbers, but with flipping which one's the denominator. DPA comes in at consistently less than 58% of the prosecutor funding. This is with county. This is the lower number with county and Commonwealth, not the higher number. And it's ranged a little bit, but you can see between 53 and about 58% over the last 12 budget cycles. If you go sit in the circuit courtroom and you look at the work the Commonwealth's doing and the work the public defender's doing, you certainly would conclude they're not in 100% of the cases, because there are cases that are called where Representative Flannery or Senator Wheeler they're there with their clients, and we're not involved in those cases. But you wouldn't walk away from that circuit court docket saying they're doing 55% of the work. Because most of the cases in circuit court, DPA is involved in, and almost all of the most labor-intensive cases DPA is involved in, the capital cases, the complex sex cases, the cases with a PFO first person that's facing possible life in prison. The percentage that DPA is in, particularly when you get away from the urban centers, is approaching 100%, and in some counties is 100%. So I raise this, not asking for anything specific, but this is more just so you know the relative funding among the players in the system. And this is not to say, and I want to be clear about this, that prosecutors have all the money they need. Prosecutors have needs too. Their turnover rate is also significant. And so we should lift all boats, but understand the relative disparity that exists right now. And when it comes to personnel, DPA, again, has about 300 trial lawyers out there. Prosecutors have 44% more full-time attorneys than DPA, and about 177 part-time attorneys on top of that. These numbers are from our survey that we've done. All of our local leaders described how many prosecutorial attorneys are in their system. That's where these numbers come from. And it's sometimes difficult from our vantage point to tell the difference between a full-time and a part-time, because a lot of those part-time attorneys would say, it's full-time hours for part-time pay, and I think that's probably right. And that's another challenge of prosecutors. But again, many more human beings are working for the prosecution than are working for DPA. Ongoing challenges. Hiring is difficult right now. We have exhausted the applicant pool. I would love to say when we post a position for a Prestonsburg attorney that we have 75 people, gunning for that position. The fact is, if we have 2, we're lucky. And then sometimes we have 0. We have some positions right now where we run a register, the process for state government hiring, and we get 0 applicants. So that's difficult. We've exhausted them. Caseload, stress, and work conditions. Public defense is not an easy job. It's not meant for everybody. And even if you can even if you're good with it philosophically, representing people charged with crimes, it's just a hard job to do. Another challenge, if you're not aware of it, is fewer law school graduates. This is a chart from the American Bar Association. The end of the chart there is 2019, but there's been no upswing since then. The number of people going to law school and graduating law school has severely declined in the last 10 years. And if you assume the percentage of people that are interested in public defense is about the same, then we've seen a big drop, and that's part of our hiring challenge. Another challenge, just the reality of state government, there's delays. And here's one where I will compare to kind of the system that prosecutors have under the Prosecutor Advisory Council. We had someone earlier this month, or maybe in August, that turned in their notice that they were leaving DPA. It was a staff attorney, somebody we wanted to keep, and they said they're going to work for the Commonwealth's Attorney's Office. In the late 90s, I think it was 1998, there was an ethics opinion in Kentucky by the KBA that said that it's actually unethical to be a public defender and negotiate a job with the prosecutor because you're representing clients against that person, and there's a possibility of it impacting your position. It's difficult to implement, but that ethics opinion is out there. And so when this person told us this, we thought, we need to know, have they crossed this line? Have they been unethical? And so we went to the attorney, and they said, no. Prosecutor just called and offered me a job, and I took it. There was no negotiation. It all happened today, and as soon as she called, I called y'all. And we believe that to be true. We don't think that was false. And why it's relevant on this screen is prosecutors and others that are outside the 18A employment system in state government can do that. When I have a vacancy, if I wanted to hire a prosecutor, or if I wanted to call Jason Nemes and say, Jason, come work for us, it would take me 90 days. A lot longer than that to get Representative Nemes probably, but it would take 90 days to get the mechanics of the hiring out of the way, because we can't do that. So that's a challenge that we have. The pay ranges I've talked about. Pay equity is just that it puts some restrictions on, you can't pay one person more than another within state government, which creates some challenges sometimes when you're trying to get very talented people that you basically have to have a standard pay rate, and lack of flexibility with incentives and bonuses. Because of our turnover and because of the reduction of law school graduates, we have to recruit nationally. We've always done that because we want to get civil rights minded lawyers from around the country that are looking to do some good in the world. We think we've got a good place for them to come work. So we've always recruited nationally. But if I'm recruiting a law school graduate in New York or in Massachusetts or Illinois, the first thing they're going to ask is, how do I get there? Because the moving, the finding a place to live, the taking the bar exam, the taking the bar prep, a new attorney could incur as much as $5,000 of expense.
Excuse me, sir.
Yes.
I just want to point out that we've got about 7 more minutes, and I want to allow time for questions. So
Thank
if
you. I
wanna
appreciate that, Madam
Thank
Chairman.
you.
So we have people that want to work for us, but they've got a lot of upfront expense. So if we had some flexibility to give some bonuses, some signing bonuses, some incentives, something up front, that would be helpful. So on our turnover, I've mentioned it, even since the budget passed. My hope, and it was naive, but my hope was once you all passed the budget and gave us additional, a pot at the end of the rainbow, we're finally going to see pay raises, that would close the door and turnover would end. That was naive. We've had 47 more resignations and 24 attorneys since the budget was passed. So these attorneys knew they were going to get a raise and said, I'm leaving anyway. Annualized over the period of time, that would be about 60 in a year. That's better than 100 from last year, but we are still facing turnover. I've already mentioned about the work conditions. COVID did a lot of things, but it created the work at home option is now something that's been a part of our work culture. Well, you can't be a public defender and work at home, but you can be an attorney for other people and work at home. So that's complicating us as well. This is probably too complicated to talk about in a short term, but the short version of this is because we've got vacancies, we're contracting with attorneys. The attorneys we're contracting with are the ones we'd like to hire, but they're doing just fine under the contracts, and so they're not interested in coming to work for us because we're contracting. But if we can't hire people, we can't cancel the contracts. So this is a vicious cycle that we're in that we got to get out of. Caseloads are still high. COVID has certainly reduced our caseloads. We're still over national standards. That goes to how difficult this work is. Just very quickly on these slides, you probably know under Kentucky law, Louisville, as a jurisdiction with 10 or more circuit judges, is required to have its own public defender system. They have the Louisville Jefferson Public Defender Corporation. We have a good relationship with that office, but they are not part of DPA. That we have a contractual arrangement with them. In this year, we are providing about 57% of their funding, and Louisville Metro is providing a little over $4.5 million. Included in that is a portion of the additional funding you gave us, so that they also could increase their attorney salaries. And just as we move forward, these are our priorities. Maintain our client services. It's very important the public defender system be independent, because we're going to do unpopular things. If we're doing our job, we're going to be in the newspaper making people mad because we're standing up with somebody that everybody else wants to put in jail for a long time. So independence is very important, so that we're not our attorneys are not punished for the things they're doing as a part of their job. And we've got a national representation as a public defender agency with training and developing leaders. We want to maintain that. So I've got additional slides with some ideas, but I'll pause here and if there are any questions.
Okay, we have a question from Senator Turner.
Thank you, Madam Chair. The statistical information you've got from the different counties, is that misdemeanors and felonies or felonies only?
Those are our total workloads, which includes juvenile cases, misdemeanors, and felonies.
All right, thank you. That's all I have, Madam Chair. Thank you.
Okay, seeing Senator Berg.
I'm just going to make a quick comment about your salaries. I have a 24-year-old that I am desperate to get him to go to law school. And straight out of college is making more than your starting lawyers are making a year. Yep. And I'm talking no experience, no graduate school, straight from undergraduate to a nonprofit is making more money than you are offering your lawyers to begin with. I mean, there is no doubt that is the problem. You're having trouble recruiting and retaining. I mean, it's just not enough money.
Yeah, I agree.
Chairman Massey.
I know that you kind of alluded to this, but I wanted to see if you could highlight a little bit. I know that in the Commonwealth Attorney's Office, for instance, most Commonwealth Attorney's Office have their own investigator. From the DPA perspective, how's the breakdown, or what assistance do you get? I hear a lot of DPAs wind up saying, we don't have enough staff. I just do my own, I prepare my own pleadings. I prepare my own responses. So they're doing not only their legal work, they're doing their paralegal work and their secretarial work. How does that work with regards to DPA?
It's a good question. For years, our emphasis has been on our caseloads because our caseloads have been overwhelming. So every available dollar we have has gone to hiring additional attorneys for many years. And one of the consequences of that is that our non-attorney staff is pretty deficient in numbers, superior in talent, deficient in numbers. We have one investigator per office. Very few. Lexington, some of our Elizabethtown, I think, has two. Some of our larger offices have two, but one in most offices. And so, in like the Boone County office has one investigator. I think actually the numbers on the chart there, but probably 4,000 cases go through that office, and we have one investigator. We have one alternative sentencing worker. Out of those 4,000 cases, probably 1,000 of them are felony convictions, and we have one alternative sentencing worker to work on those. We have probably our statewide ratio is 3-to-1 on attorneys, on secretarial staff. So three attorneys would share a secretary, and that secretary is also the receptionist and the person who goes to the clerk's office and gets the files. So the attorneys in our office have very little associating support. So yeah, our attorneys are writing their own motions, they're typing, they're filing, they're investigating, they're calling witnesses. That's what being a public defender is in Kentucky right now.
Okay, Representative Flannery.
Very brief question. I was looking at the caseload report. Do you have any data that distinguishes between felony and misdemeanor cases?
We do. Yeah,
and juvenile cases.
Yes, yeah, we break it down by all types of cases.
If you could, if you all could maybe email that to me, I'd be interested in looking at that.
Absolutely.
Thank you.
Okay, seeing no further questions, would you like to just sum up?
I come today just to provide information. We are working, as Representative Massey has said, we are working with a small group that's interested in helping us, and we are greatly appreciate that. It's very possible that there will be a bill in the spring making some changes. Kentucky DPA's authorization statute, which is in Chapter 31, has essentially been unchanged since the late 70s. And so there are improvements, and we ask for your support when we come to you in the spring.
Okay, thank you very much for your testimony. It was very interesting. And you have your PowerPoint for the last ones we had to gloss over. And do I have a motion to adjourn? We are adjourned.